Okay, I would like to welcome everyone to the May 2024 policy meeting. And I will start with asking Ms. Kitten if there's any announcements.
This month, we are kind of working offline to come up with a template so that we can really, at these meetings, focus on content. So you should have seen something from Ms. Ionetti for recommendations. Hopefully next month, we'll have that robust template with numbering, mechanisms, and headings so that everything can look the same when you're seeing it for the first time, and that we're all operating from the same starting point. So hopefully that will be a really nice thing to move forward to. That is my only announcement.
And you may hear us talk about it. Those of you who aren't on the committee, you may hear us talking about certain things being numbered a certain way or being in a section. And that's what we're talking about, the new layout that we're working on. Okay, and with that, we have last month's minutes to approve. Committee, yes? Read them, they're good? Okay. We'll move them forward to the legislative. And now we're going to start with old business, second readings.
As always, we'll go through second readings. All adjustments would have been made based on last month's discussion points. Any thoughts, feelings, things that we need to point out, those are all listed under public content in second readings. Bless you.
Like to start, Jenna? No. Looking around as Jenna double checks.
I have a couple small things.
Okay.
You want me to go first?
Go ahead, go first.
Okay, so yeah, just a couple small things, some of which I had written on my copies, and I just can't remember if we talked about it last time. So one of them was on policy 800. I think I brought this up last time, but we may have decided not to address it specifically in the policy, but the concept of not keeping data longer than we have to, just because it kind of exacerbates the kind of data risk. So again, it's when I read what's now in the delegation of responsibility, where the way it's worded at the end, it says, you know, what information / documents data need not be retained. Maybe that was kind of addressing it. So that's number one. And then next one is a super nit, which is in 830. There's some language in the delegation of responsibility that's in bold. I don't know why that was in bold. I had that in my notes from last time as well, but I may not have raised it. I kind of go back and I compare. Did everything I have in my paper copy make it in? I think that's what I had on second readings. Not a lot.
Anyone else with the second readings? Oh, go ahead, teacher.
Yeah, just sort of triggered by a question from a community member in the meeting. For number 907, the visitors to schools, it's sort of implicit that that's during school hours, right?
Correct.
Yeah, and do we need to state that, or is that something that is self-explanatory or implied?
Let me take a look at the definition of visitor and things like that, and if we need to apply those things, that's a good point.
Mark?
To Jenna's point on record deletion, or probably better phrase the way she phrased it, not retaining things longer than we need to retain them, there is text in the AR under a section called Retention, Storage, and Destruction of Records that says, nothing in these administrative regulations shall be construed as a guarantee that every applicable record will be destroyed on the exact date on which the minimum retention period has been satisfied. And I understand why that's important wording, because that's going to be hard. But I kind of agree that it would be nice to have something that, I'd like the board to set an expectation that things will not be retained well beyond that point. Yeah, some
Unless
sort of
there's a need,
fuzzy wording about a reason, within a reasonable time frame after that point arrives. And I would put it in the policy rather than the error, because I think that's something the board is specifying.
Right, because we do have that exception about if we think it could get caught up in litigation, not to destroy it. So we can't say, we have to have some.
And those would be kept for litigation holds, and that's kind of above and beyond all of those.
That's already an
So-
exception to
Yep,
that rule
okay,
anyway,
yep.
yeah.
Okay, so we need to add that to the policy. We agree, if the committee agrees. And then is that a substantive change?
I don't think it is, and I specifically don't think it is because I think the language that we're proposing, that I'm proposing, that I think Jenna will agree with, is very fuzzy in nature. I mean, I don't think we want to say within a month or within a year. I think we want to say within a reasonable time frame, some such wording like that. So because of that, I don't think it actually substantively changes anything.
I can get on board with that.
Like the committee is in agreement? Okay. Anything else? The second readings? And with Teach's suggestion, again, is that a substantive or we're just, well, we don't know the answer. Visitor might,
I'm going to look at the definition. I don't think that anything we would add would be substantive because it's the intent of what we're talking about, but I'll let you
Okay.
all agree or respectfully disagree with me.
I agree.
I agree as well. I think it's implied, I think, when you talk about educational programs, that it would be,
yeah, I mean, we don't have it for other school events that you have to show your ID and everything. Other times you enter the building that's not during the school. So I think it is implied. But we can add it in there so it's clear and we're not making any substantive changes. Hard to say. Okay. With that, anything else on the second readings? Okay, so let's move on to first readings, local policy review.
So in our new business first readings local policy, you'll see 206, assignment of schools within district. So let's go through that. We talked about a legacy clause adding to the AR, and then a map of the elementary school designation areas has been added, attachment A in the AR as well. So thoughts, feelings, feedback on any of these changes?
You want to start? Go ahead, Jenna's going to start.
I think this is a lot clearer now. I had one question, which is, so in the situation that we talk about, it's in 3.2 now, about if we would need to assign a student to a particular school based on something that's in their IEP. For example, we talked earlier about how we have certain supports at FWES, so that might be a circumstance where we would say, we're going to assign you. Would we provide transportation? I would think so, but it wasn't clear to me from this. So we would provide transportation.
Yes, for
in
a
that
student with an
situation. Okay.
IEP, we'd put the transportation within the IEP. Yep.
I think that's also covered in the transportation policy that is also on the docket.
Yeah, I mean, you may want to cross-reference it or something, just because I could envision a parent who's in that situation may not think to go to the transportation section, right? It could cause some initial
No,
angst,
but I'm sorry, but it's in there under the discretion of the superintendent to maintain, right under there, it says, students assigned to schools for this reason will be provided transportation by the district. So,
Are you in the AR?
There's a different spot.
That's for a different reason.
oh,
Yeah.
I see,
Yeah.
I see, yeah.
I think is that the sibling section, I feel like? I forget, but yeah.
This is,
No, that's for the
size.
section on class size
Yes,
balance.
okay, yep, yeah.
Okay, do you have more?
That was it on that one.
I have a few things. Anyone on the committee? Want to go? Okay.
I just noticed the same thing Jenna did, the one spot where it's not clear that students who are placed out of their home building, their neighborhood school, will get transportation for special ed reasons.
Okay, so my two things. Do we need to specify where we derive the authority to establish the following policy? So that's going to be part of the new format that we talked about. That we want that to be in there. Mark, do you want to elaborate on that? Because it's your wheelhouse.
There's a point where we will want to start making that the norm, and this, we're in first readings here, this could be the first one.
Right. Okay.
Yeah.
So we need to identify that and put that in under authority. And then in either guidelines or the delegation section, does the committee think we want to say the administration will make school assignments readily available? Like, so that we know there's one section where one area of town where it was kind of unclear. So we want to make sure that they don't have to go looking through ARs to find it. Or, go ahead, your thoughts.
So I think I understand what you're asking, Ms. Ionetti. I think that, what typically happens when a child enrolls is that they talk to our registrar, and then the registrar will look very detailed at their address and the larger map. You're correct, the map that's attached here is not going to tell them where my exact address is, but the registrar does that with them in conjunction with transportation if we need to figure out exactly where it is, and then based upon the lines would say, you're going to be attending Maple Glen, and so forth. And then if a parent has a question, it might, take a different path from there.
Okay, and thinking about people moving in or moving around the district, they have to call the registrar to get that info? Like, we can't post?
Well, they
we
need to
wouldn't post
change their
anywhere?
address. So when they want to make a change within like Infinite Campus, because they want to change the address that they live at, their mailing address, and continue to provide proof of residency, yes, it goes through the registrar.
Okay, but if they're thinking of moving and they want to know, where am I gonna, what school does that land? If it's, if it's unclear.
I mean, most parents, I think, probably, like, your school and your school office is usually who you go to because that's where your comfort level is. And many of our secretaries would know, oh, that address does not lie within our sending area, or they might contact the registrar or direct them to the registrar. I think that we can specify something in here if you want, but I think most families reach out to either a school building or to the registrar when they're in that type of situation.
I mean, I know, like, we moved a few years ago, and when I know in the real estate listings, it was wrong. Like, they would say, oh, you're at this school, you're at that school, and I know, because I'm pretty familiar, what elementary school it's going to. So I guess I was just hoping there's somewhere that I could just, like, people could look online and know for sure.
We can think about what our registration page looks like and put a post on there. If you want to add something to policy that says, incoming families or registrations can talk to the registrar, I don't know that people go to policy either when they're moving into the district, though.
Yeah, I guess I just wanted it somewhere, but that, and I don't.
I have seen in other districts on their websites where they've done an interactive map where you have the ability to actually put in the address, and then from there, it actually will identify what school the child goes to. So that could be something, I could look into a little bit more as what technology is used for that. But then for a family that is trying to figure things out without having to reach out to the school, you can put in the address, and it'll actually, very similar to the map that you showed, it will identify, where the student would go to school. So I could get some more
That'd be great,
information.
yeah.
I think that would be helpful. I know anecdotally, when things were a little looser, it didn't even occur to them that certain neighborhoods don't go to certain schools. So like there's a little section of Drescher that's walking distance from Jarretttown that goes to Thomas Fitz, or a big section of Drescher that's walking distance to Jarretttown. And then when parents went to register, they just said, I'm here to register for Jarretttown, and we're able to register for Jarretttown, and they registered for the wrong school. So anything that could make that clearer, I think now that we're having more clear policies around going to your school that you're districted for will resolve some of that.
I just want to weigh in. I don't see that there is just on the registration page, does say, please contact district registrar for more information. I don't know that this is a policy matter in terms of specifying something to that level of detail.
Yeah, I mean, when I was looking at it, I'm thinking more, like initially, because there is that one section where they were divided between two schools and it was not assigned. So it would be nice if they could, when they hear about this, can go look at the map now.
And I would like to share with the board that Dr. Ortiz and I did meet with representatives of that community to gain some historical context and where they think things are at right now. My understanding is that there are what I'll call delineations from where your home is to which school you should be going to, and that those families then, if they would like to make that request between the two schools, they have then done that in some way. Sometimes it's word of mouth, it's to the registrar, sometimes it's been at the building, as you heard Dr. Thomas mention, but there is a clear delineation of where they should be going based upon their residency, and then there's been this ongoing practice for that very small community. It does date back quite a while and have some historical context to it.
Okay, Jenna, you want to weigh on it? I'm trying to get the feel for the committee. Sue's kind of like, we don't need it. Mary Beth and I are like, maybe we do.
I mean, this is one of those policies that's, I think, very clearly titled, so if you were having a question about it, it is in there. I certainly have no objection, though, to putting it somewhere more prominent on the website if we feel like people are, it doesn't hurt. I'm kind of agnostic, sorry.
I have a question that's not maybe a policy issue, but again, like a communications issue. This feels like a big change, and I wonder how we're going to get the word out to the community that things aren't going to be so flexible going forward.
If I could just chime in on that, I think maybe we would need to define what we consider to be big. We did indicate in the policy, we have a legacy clause in there that indicates if you already have a variance, that you would continue in that. The basket, I know that, I apologize, I'm looking for my data as we're talking here, of the number of students. Here we go. The number of students that we currently have in 23-24 is 33 students representing 26 different families. Those students would continue through the rest of their, elementary career, and it would really be those new. We could certainly, I guess I'm not sure that this is really something that needs to be communicated to the whole community when it's a small group that we are allowing to continue, and it would be any new requests. Would be my wondering.
Yeah, I'm even thinking of, I think I know of some people who registered for kindergarten next year who have moved and have registered for the area.
What I would recommend would be that with the support of our registrar, and I wrote myself a note that we need to talk to our building principals and our school secretaries to make sure that they understand that they have to check the address. And, in my past experience, if somebody showed up to one elementary and when we checked their address, they were a different elementary, we then had a conversation with them so that they knew you need to, register at the different school or what that may be. So I think we could go back and look at any registrations so far and confirm that they registered for the correct buildings and then have individual conversations with them.
And the legacy clause for younger siblings, when the older sibling is in the building that they, isn't for their address currently, have we figured that out?
I think the board would need to, provide some direction to administration if you want us to continue that for siblings moving into the future. I recognize that it could be a difficulty on a family to have kids in 2 different buildings, but I also recognize that we could have a child in kindergarten right now with 5 siblings coming through, and do we want to continue that practice for all of their additional children? I'll do whatever the will of the board is.
Go ahead.
So I felt like the wording was intentional because I feel like we used the word students in the legacy, not families. So to me, to that point, I read that as if you're a sibling who is in preschool, you are not grandfathered in regardless of what your older sibling has. And that would be my preference. I really think we have to kind of rein this in a little bit. And I think, letting people kind of stay the course with the student that they already have enrolled, because I recognize that can be disruptive. They may have made certain decisions based on that, but my preference would be to not kind of keep it perpetuating for subsequent younger siblings, if they're not already in our schools.
And we could create a communication and send it to these, 33 or 26 families in case they do have younger siblings, so that we are being proactive in communicating that.
Agreed.
Yes, I'm fine with that. But we still have the unresolved question of, do we put the interactive map up, or do we ask for that in policy? Mark, go ahead. We need help.
Yeah,
We're
I really
torn.
don't think that's a policy issue.
Okay.
I mean, the board could direct that the website shall include something, but that's not a typical thing that we do. I think we should do that, but I don't think that's a policy issue. And I also happen to agree that we shouldn't grandfather future siblings who are not already in one of these situations. And in terms of communication, I don't think this is a big, huge district-wide big change or anything, but I do think it's important to notify those 26 families.
All right, so I can I'll flip and say, it doesn't have to be a policy, but I would love to see it. I think it would be helpful to people. Okay. Go ahead.
Sorry, I didn't, so I had some comments also on the AR before we move on. I was sticking with the
Yeah, no,
policy.
I do have AR stuff too. Go
Yeah,
ahead.
we bled into the AR, so I
Yes.
guess let's go there.
Let's go.
Okay, so under relocation of student from one attendance area to another, number 2, so the superintendent will review the request. If the principal of the school of original assignment recommends the rejection of the request, data relevant to that recommendation must be included, but I wasn't sure in what. Is it considered? Is that, I don't know if included is the right verb there.
I think the way we are trying to work this is using that form that we put in policy 003 for exceptions, and that they would then include any justification on that form, like to make the official request in writing on that form that we created in policy 003. And then anything relevant to data, I guess is a loose term, what might you consider the data, but whatever they feel is their justification should be in that form.
Is it though, but isn't it the parent requests it? And actually, I just noticed, by the way, in number 1, we say parent, we should be parent/guardian, sorry. But yeah, I thought the way the process worked is if the family, I'll say, if the family wants to request it, they're filling out the form. But what we're talking about in 2 is the principal, if they want to recommend rejection, that they would bring forth relevant information. But does that go in the form then?
I apologize, Mrs. Evans. My mind was thinking the form that the requester, you're correct. This is about if the principal of the school recommends rejecting that data relevant has to be included. You're right, it doesn't say where it has to be included. We could change that to considered if you think that would be better.
Is the right verb in that sentence must be provided? Because it is the principal providing said justification for it.
Then you're at to whom, but yes. I think
Touche.
it sounds like, so this is the superintendent will review the request. That's where it has to be included in presumably there's a packet of information that the superintendent is going to review. in the beginning of this paragraph. And that's where both the form from 003 and any information from the principal must be included in the stuff that the superintendent reviews. I don't think stuff is the right word, but.
Maybe provided instead of considered, or, provided to the super, because I think the way the process works is family fills out the waiver request, I'll call it. Principal sees that, principal may feel like, nope, I don't like it for whatever reason. They're going to provide their data or, whatever it is that they're backing that up with. But I didn't feel like it goes in the request, because again, the request is coming from the family. So it just was like a hanging, it's really, I guess, an adverb technically, I don't know, but yeah.
What if we change it to how I did on the screen there? Data relevant to that recommendation must be provided to the superintendent.
I had something in the AR about the twins and multiples. I can think of a bunch more scenarios where family members would be in the same grade, immediate family members, and like blended families, adoption, foster kids, like all different reasons why, and that discretion about same class or different classes wouldn't just apply to twins or higher order multiples. So just, wanting to broaden that a little bit.
Certainly can, if the board wants us to add some language to consider that.
Yeah, I had the same note. That maybe it says sibling.
Or even more expansive, it's students in the same household or, something, because, yeah, you could have, is a step sibling a sibling? I don't know, so. But, yeah, I agree. I think making it more the concept, right, is you have two kids in the same house, whether they're twins or, they just by happenstance are in the same grade. Yeah, I would think the spirit of what we're going for here is that we're trying to give families optionality there. I will say on that, go ahead.
Can I just weigh in? As an identical twin?
I have twins. Just saying.
I think I'm not saying we shouldn't broaden it. I like the idea of broadening it. But there is a meaningful difference between the experience of being in the same class or different classes for an identical twin than there is for step siblings who may be in the same house. And that may be where that's coming from. But it also just might be historically that wasn't the kind of thing we considered. And I still think broadening it makes sense. But there is a meaningful difference for identical twins.
Yeah, I think that there's a statute or something about this with twins. Does anyone know? That might be where the wording comes from.
There is. I think one of our previous conversations here, Ms. Iannetti, you actually brought that up, and I think Mr. Giazio provided that to us, that the language is in line with PA code. That's probably right where it came from, code. I'll keep looking in my notes here.
That's probably why it says twins and higher orders, because they're that is, right, you didn't know that?
Sorry. Burn.
You love your statutes.
So if it's listed, I generally read it. But yeah, I mean, is there any reason, so you're probably right. You're probably exactly right that it comes from the statute, probably says twins and higher multiples. We can always do more than what the law allows. And
Right.
I think what I'm hearing is no, I just think this obviously does not happen very often. And they're still going to the proper school, so to speak. We're just talking about giving families the optionality of, do you want them in the same classroom or do you really not want them in the same classroom, right? And
I think you have to give families some input, but there are limitations to that input.
The language comes from section 1310.1. So it is right out of school code.
And so maybe we can put that in the AR, and then Jenna will know.
I would have read it.
You would have read it. That would be good to have. We are trying to put the citations in moving forward, so that's part of our new format. Put that in
So
there.
do you want language added, a parent guardian of twins or higher order multiples, or two students residing in the same household who are in the same grade level at the same school? Do you want that added like I did up there, or take it out? This green right here.
Or immediate family members who might not even reside in the same household.
There has to be a line somewhere.
Yeah, I mean, it's not like, you're right, unless there's one class,
Yeah.
you can,
But, you know.
be reasonable that put them in
If they're
different
cousins who
classes.
both live in Upper Dublin and they're in the same grade, like, you know, but not in the same house, like, there has to be a line somewhere, and I think, you know, the same household is a good line to draw. I do question on this topic, though, whether this actually belongs in this policy. It seems.
Literally wrote that.
Yeah.
Yeah,
Unless we
because-
change the title, because it's about schools, not
Right.
classes.
Isn't there something else in another policy, and I apologize for not digging for it, but there's something in another policy about making specific teacher requests. And this feels like where that goes, and rather than in this policy.
Okay, but it's different, I mean, because there is a statute, it's different than your typical,
It belongs in policy somewhere, I'm not sure it's this one.
yeah, no, it is, well, yeah, it's in the AR. It was
Or,
there before.
policy
Yeah.
or AR somewhere, but.
I think we might get the spirit of what we're all trying to say. Why don't Dr. Smith and I look at where this, might go, some language, and maybe bring that back?
The one other word I would add, by the way, is I think we're only probably talking about elementary school
Yeah.
with this, but it doesn't say that.
Okay, you got, on this one. Okay. Jenna's got some more.
So one of my questions was, again, in that section, wherever we end up putting it, excuse me, it says that the request must be made no later than 10 calendar days after the first day of each school year. That feels late? I mean, isn't that going to be disruptive once you've got classes set? I mean, and again, this is not my area, if that's when administration wants it. It just stuck out to me that I would think you'd want that request before you've made your class rosters. But
Well, I just want to say that, sometimes you don't realize that they're, like, if we change that, then do we have to change the date that families are notified of what class their student is in? I guess that's what I'm trying to say.
I'm just going to share, in my experience, families in this situation, this is on their mind, and they reach out well in advance. And to your point, Mrs. Evans, absolutely, we would want to know as soon as we can. As a building principal, I talked to those twins at the end of this year. I was talking to their parent about, where do you want to be next year? Do you want to be together? Do you not want to be together? I think that's good best practice. So we could change this if you want to make it clear that they have to let us know in advance of the school year. I think this basically provides them the option that if we haven't done that proactively, you have 10 days after you find out they're in the same classroom because you were busy at the beginning of the year to request a change.
Well, also more importantly, I think they may have made a conscious decision. I had my kids together for kindergarten, first and second grade. Let's try separating them for third grade. And then, after a week, you're like, oh my God, that was a mistake. So,
Except it would
or
have
actually, it's
gone
probably going to be the other way. That would be the
yes,
mistake, but yeah.
yes.
And actually, now that I see it, it's in the statute. Now that I have the statute, I just pulled it up. It does say they must request it no later than 10 days after the first day. So that's probably where that came from. This is why I love statutes. They tell you everything. Okay. If they're well-written, they tell you everything. It's a big if. Okay, let me just see. I had some little nits grammar things we don't have to cover here. I think that was it for me.
Anyone? Go ahead.
There's a couple things in 206, both the policy and the AR, that I think belong in the other place. In the policy, it does say that the board determines attendance areas, and therefore I think the map that's attached to the AR really should be attached to the policy, not to the AR, or both. And then in the AR, there's a bit about having a board hearing. If the superintendent moves the student in order to maintain class sizes, they have the option of a board hearing. Since there's a board hearing there, that has to go in policy, not in AR. I mean, it's not up to the AR to authorize, to say a board hearing is required. The board has to say that. So I think that part would belong in AR. On that topic, I'm really not wild about discretion of the superintendent to maintain equity in class sizes. Like, to say, we determined a map, but they can say, you know what, I'm going to move this neighborhood over there because class sizes are a problem, without the board getting involved in that. That, it strikes me as surprising that that's an authority delegated to the superintendent. I'm curious whether that's common.
Your point, Mark, it feels like something, if that's an issue, then you adjust the catchments, right? As opposed to just moving students around.
Which is a big deal. And so we're just letting the superintendent make that decision without, I mean, sometimes maybe you just have to, but that's why I'm curious whether this is a common clause or not.
I work at a school where kids get capped out every year out of their neighborhood school. They don't change the catchment areas. And then if there's room later, they have the choice to go back or stay where they got moved to.
So your thought is that this is not uncommon?
We're lucky that it's not common because it's difficult.
Yeah, I guess I wasn't considering because we haven't had buildings close to capacity since before Maple Glen was built.
My experience, Mr. Sirota, is that if this would be a significant number of students, like I want to move a whole neighborhood, that would be a board conversation and seeking board approval to change something like that. That's happened once in my career, and that was the process used. There was a lot of data presented, a lot of conversation, and then the board made that change and what those communications were. I took this to mean more like a one-off or, one or two here or there because of numbers, but certainly we're not in the position that Dr. Thomas mentioned.
Yeah, I mean, if that went back to the board just moves slowly. And if there was a situation where, at the last minute, a bunch of students enrolled and we had I think we have to give that, like.
Yeah, the
that's
capacity
what-
problem was not something I really consider. That does change my opinion a little bit. But anyway, it's only first reading. I'd be curious if you can just find other policies and see if it's common.
Something to be proactive about with the new apartment complexes going in and things along those lines. There could be a wave of kids from a certain area that isn't anticipated.
Even without new development, it can happen, just a whole bunch of second graders move into the same neighborhood at the same time. Nothing, that certainly can happen. It's not statistically likely, but it's not zero.
Go ahead.
Mark reminded me, I had one other thing. So in that section, I think it's the same one you were talking about, where they have the ability to petition the board. There's a sentence in there that stuck out at me. So it's in this paragraph that starts with within 10 days. Near the end of that paragraph, it says, "The board shall not overturn an assignment unless it finds that the decision was exercised in an arbitrary or capricious manner." That struck me as odd language in an AR to dictate how we would make a decision, so.
Yeah, I mean, the whole thing, the same thing is dictating that the board shall have a hearing without the board authorizing that hearing just seems wrong. So I think that whole thing, if you move it to policy, then that's fine. And then we're putting, that statement will be binding on future boards to act only only if there's arbitrary or capricious action, but.
Yeah, I actually don't have a problem with the statement, it's just putting it in an AR was odd to me.
Is the recommendation for this entire section on discretion of the superintendent be moved into policy to say the board provides discretion or delegates to the superintendent too, and then take those two paragraphs into policy?
I think that's the only real way to do it, yeah. Assuming we want to continue to maintain the board hearing solution to it, another way to do it, I suppose, would be to have some other mechanism. But again, if we can figure out what other districts do around this, then.
And we'll check. Typically,
Yeah.
board hearing language is mandate, so we'll check.
Okay. So moving on from 206.
Mrs. Ionetti, I'm sorry to interrupt you. This one has been, we've talked about it several times here. I just want to clarify with the things that you're asking for, are you wanting to keep it in policy committee, or are you saying we're moving it to first reading to board and we'll make these changes like we've done with some other policies? I just want to make sure I'm clear since we've talked about it several times here.
I mean, I know we've thrown a bunch of things out, but I think it's ready to move on. I think we worked through the big stuff personally.
It feels like it's still like being iterated, but I'm not totally clear on when things move.
It is still being iterated, but second read, that, there's still another opportunity for revision in the second read, so I think it's fine to move it to second read.
Yeah. I think the big things have been decided. Okay. Any other questions about 206? All right, so now we move on to, I guess, 603, really.
206, we went through. We currently do not have any legal or PNN recommendations for this month's policy committee, so we would be looking at first reading on our review cycle policies, which we would start with 228. Government. We added some language, this just came up in our review, we added some language reviewed by our district solicitor regarding the role of student government. So any thoughts, feelings on this one?
I don't have a lot, but under guidelines, so for 3.1, do we want this to include elementary? I mean, I just know, for example, Jarretttown has a student government. I don't know whether they all do, and it says that it's directing the principal to encourage and maintain a structure. So I just don't know whether all of our elementary schools are ready for that yet, or if we want to just change it to secondary.
They do.
They all have it? Okay, all right. Yeah, I mean, I like it. I think it's great. I just didn't know if they were all doing it yet. So it's new for Jarretttown, so.
Okay,
Cool.
I had the same question. Go ahead.
The only other thing I had is in 3.4. The last sentence where it says a student government association may make recommendations. Frankly, I would change may to is encouraged to. I mean, I think that's, I think we'd like to encourage our students if they have things that they want to bring up. It may just sounded a little bit like, well, you can if you want to. And I know that's not what we mean, but I think it's a great thing, so.
Anything else on that one for you? I have a few.
Last sentence in guidelines, Dr. Smith?
Yes.
And may is encouraged to.
I
Use
think
the
I would
word
kind of.
concern. That's why I said it.
It doesn't sound very policy language to do it that way, but I think you could turn it around and say, however, the administration welcomes recommendations on any topic of student concern.
For me, it was because it had the word concern in it, right? It's not just like, oh, we want ice cream at lunch, right? It's, if there's something concerning, I want to encourage people to voice it. But yeah, I'm fine with wording it that way.
Jeff?
Had a couple on this one. I'll start where Jenna was first at 3.1. Is 3.1 inconsistent with 1.2? Because 3.1 says the principal shall encourage and maintain a structure for student government. But 1.2 says we only recognize the Sandy Run Middle School Student Council and the SGA at the high school. So I don't know if they can encourage and maintain any other structure. That seems to be a disconnect there.
Agreed.
And maybe just changing the word structure. I mean, maybe it's like encouraging and maintaining the approved student government. I don't know, but something in that language there.
Yeah, I had something similar. One, it shouldn't be an authority. It should probably be in guidelines, and then is it even necessary to be in there?
It's definitely necessary, because what I agree, it doesn't belong in authority, but what the statement in 1.2 is saying is that this is the one. If some other group wants to claim that they're the student government and, take some authority, that doesn't have any weight with the district.
So
And
why
that's
does it just say Sandy? Why
Why is it just those two schools? And I agree that seems to be, if they are at the elementaries, we should name all of them.
I think that there are various clubs and organizations at the secondary level that this is saying, these are the official recognized student government voices in these two arenas. At the elementary school, there is only one structure. There is only one opportunity. Does that make sense? But I agree, maybe we can clean that up and make that flow a little bit better.
On that point, on 1.1, do we need to qualify that it's for student government? It says students shall have the right to organize, conduct meetings, elect officers, and represent, and petition the board, blah, blah, blah. I felt like I was reading like a labor union statement that students can organize. I think we've got to have some qualifier in there, unless people disagree.
That could be as simple as students will have the right to organize a student government, comma,
Yeah.
conduct meetings.
Yeah, something like that. And then my last comment was in 1.3, and this is kind of a question. It says the charter and the bylaws shall be duly adopted by the members of the student body it represents. So does that happen every year since the members are changing, or does it happen once and it's okay in perpetuity?
My guess here, and I will have to check this with Mr. Schultz and Mrs. Martonic, is that they have bylaws that are approved and they aren't relooked at unless something comes up, and then the group that they are representing at that time might relook at them. I can say that as an example for National Honor Society. I know that they want to look at their bylaws or something along those lines. So when an issue comes up, they might look at it. I do not think it is an annual that the whole student body votes on it, but I can check.
Just to bring some, I don't know that we ever closed the loop on this in terms of the board recognizing an organization. It sounds like the sentiment, like the purpose of that statement, whether it goes in authority or it goes in guidelines, is that there will be not more than one officially recognized student government association per school. In which case, then I think you are inclusive of the elementary schools.
Good point. Go ahead.
So I hadn't noticed this before, but now since we're talking about 1.3, do the charter, constitution, bylaws, are they really adopted by, because this says the members of the student body it represents. So to me, that reads, if you're talking about the middle school, it's all the middle school students. Whereas I think what it really means is the members of that association. Typically, it's only the organization officers or, whatever who approve the bylaws as opposed to literally every, but I don't know,
They're only approved by the representatives who approve them, but they govern the entire student body.
But this says they would be duly adopted by the members of the student body. So it makes it sound like if you want to make a change to the bylaws for the Sandy Run, SGA, you need a vote of all of the students in 6th, 7th, and 8th grade, which sounds like a lot.
I'd have to check, honestly, to find out what the practice has been. I'll find that out.
I had a couple comments, which are sort of covered, let's see. So under authority, we want to keep the citation in there, and then we want to add some verbiage about where the board derives this authority from. And then I think 1.1, 1.2, 1.3, and 1.4 all move to guidelines. Oh, Mark gave me, yes, the guideline expert, okay. Okay. in our new format, we'll have a space for definitions, but we can just leave it blank or say no definitions, just so our numbering makes sense. And then the delegation, that should be after guidelines? In the new format? I mean, you don't have to do this now, but I'm just kind of going over that. And then, do we need the attachment? I don't even remember what the attachment, I did this earlier today. Oh, there's like there's a constitution on there for the high school. Like, is that the right spot for it? Does it go in?
Yeah, I don't think it belongs here. This is policy established by the board. I don't think the SGA Constitution or any organization's bylaws need to be attached here.
And then does this one get an AR? Was it one? I don't think I saw one. I have too many tabs open. So it doesn't have an AR right now. No. I guess. Okay. All right. Go ahead, Mark.
I just want to double check. So in what's currently 1.3 and 1.4, it says that the bylaws for the organizations have to be approved by the superintendent or superintendent's designee, and the superintendent shall appoint a qualified member of the faculty to liaise. So Dr. Smith, is that the superintendent or is that the principal?
Well, I think technically, and Ms. Kitten, correct me if I'm wrong, those recommendations come over through the HR, from the principal to the HR's office, and then I don't know if you want to deem them their superintendent's recommendations, but they do flow through the building, right, over to you in terms of.
They flow through the building. Ultimately, they come here for approval for extra duty responsibility affiliation. So, I mean, we do have multiple levels of approval for those.
So it sounds like at least 1.4 superintendent is the right answer. For 1.3, do you actually want to be the one who's approving these bylaws, or should that be the building principal? Is there important for there to be commonality, and therefore it should be you, or?
I'm going to pull the superintendent's designee card here on this one. Again, I would imagine this is principals, or like here at the high school, it's probably Mrs. Martona, because she oversees the activities. So I think it's okay to leave it as superintendent's designee, but it clearly is not me, if that's the question that you're asking.
Well, in practice, it's not you, but is it important for you to have some direct authority over the approval? Is there something that could come up there that really is, the superintendent really needs to make this call? Or is this building level question?
I'm sure that kids could probably recommend something in their bylaws that maybe, my eye on it, or that Mrs. Martonic would say, Dr. Smith, maybe we need to look at this piece of it.
Okay, so we can leave it the way it is. I just wanted to just talk through that and make sure that was right, because it seemed to be different than the stuff in section 3 that talks about the principal or principal's designee. So I just noticed that difference and wanted to make sure that's how we wanted it to be.
Okay. That's it, we're good? Okay, moving on.
Okay, final in this area, 810, transportation. Our district solicitor has confirmed that the language in the policy does not prohibit the district from considering the use of that side stop arm camera, such as bus patrol, and therefore no policy language is necessary regarding this. But any other thoughts, feelings, or comments on this?
It's just right here, it's so easy to look. I don't want to always have Jenna start, but I will. She's ready. Go ahead.
All right, so under authority, so 1.1, where it says to ensure the safe and efficient transportation of students to and from school at regularly scheduled hours. That just struck me as odd. I want them to be transported safely and efficiently at all times, even if it's not at regularly scheduled hours. So I don't know, unless that's statutory language that I missed, I would take that out, but I don't know. Again, it seems odd. More substantively, there's a section when we get into the 2.6 background check section. So first of all, it says in 2.6.2 that we have to be told at the beginning of each school year whether any employees, have been charged or convicted, et cetera. And then it goes on in 2.6.4 and 2.6.5 basically talk about, and there have to also be procedures for, employees to notify if they have, I guess in the interim been convicted of anything, but it doesn't really say by when. So it's just a kind of a global comment. I don't know whether it's best to put it in 2.6.4 or 2.6.5, but obviously that's something we'd want to know about immediately. So it does say there's supposed to be procedures, but I just think a little more specific timing on how quickly we need to be told about that, because again, I would think that would be absolutely immediate. And then the last thing I had was in 3.3, where it says the school bus or vehicle driver is responsible for discipline, which makes sense, but I feel like we should add kind of in accordance with district policy. Yes, I agree they're responsible for discipline, but not no holds barred, so that's all I had.
I just wanted to raise the issue of the transportation shortage and the lack of transportation to some extracurricular activities. And then the issue of kids being transported or leaving school pretty early because of those scheduling issues and missing classes. And should any of that be addressed in this policy, or does the board want to direct the administration around any of those issues? Like, with the shortage, should we be directing the administration to find contracted transportation services to fill some of those gaps? Should there be any guidance as to which activities get transportation and which don't? All of those types of issues that are kind of hot right now.
So certainly, if the board wants to direct administration, you certainly can if you have an order of priority or preference. I do, however, think that many of these situations occur on a day-to-day basis, and it's not as if we know well in advance that on May 2nd, we're not going to have enough drivers to run a particular team or a route. And so we do need to have some flexibility to be able to do that, nor can I get a contractor in that short period of time either to turn some things around. So I think that we probably do have an order of hierarchy. First and foremost is getting our students to and from school, and then activities would be the second tier of that, sports and athletics and so forth. And then we have to triage basically to, do the best that we can to transport our kids. In my experience, sometimes that's been early transportation, sometimes it's been late, sometimes it has been, working with parents. It's really been a range of things just to get kids to be able to have an opportunity to participate.
I know in some cases kids aren't participating because of the transportation issues, so that's something to consider as well, or that transportation for one particular sport has been canceled for a whole season and not other sports. And that's kind of projected like a month out or something like that, and not a day-to-day issue. Hopefully we get through it and it's not an issue, but I didn't know if that was something that could be included in here.
I guess my feeling is I don't want to put something in here and sports don't happen. Like, I know it's not perfect and we don't love it, but for the most part, it works. So I would be afraid to put anything in here that would be like, then there's that sport doesn't happen today because of the way we worded it. We know there's a shortage of bus drivers, and I think that the administration is doing everything. There's no reason why they wouldn't do everything. Like, there's no upside to not getting kids where they need to be in a timely fashion. So I don't know that we need to direct them. I don't know, those are my thoughts.
I'll stream of consciousness answer two of the points that were brought up. For 2.6, to Ms. Evans' points with the criminal background checks, I'm going to look at what is Department of Transportation and what is PDE, because there are varying requirements for both. And then I'll cross-reference, I'll put in some citations to what policy language, because there is timeline requirements and we don't need to be repetitive, but we can definitely point to that. And we can point to Department of Transportation language as well. Because we do have to abide by both for transportation. So that's an easy fix. And then as far as staffing goes, just anecdotally, we are only currently down 2 drivers, and we do have a very nice list of substitutes, which is nice, and a lot of ancillary staff who are also certified, that have CDLs that can drive. So we are very, very lucky that I think our transportation is getting as healthy as it has been in the past few years, which is great. And as far as outsourcing goes, when positions are empty, we do have a nice relationship with our unionized environments that we do temporarily outsource when we have substitute needs, and that's for all positions. So we are never just saying, well, it's not filled and we're not trying. We do temporary outsourcing, we look for temporary outsourcing. Transportation companies are finding it harder to find drivers than we as a district are. So those are the 2 things that I just wanted to point out that I've been hearing.
To Mary Beth's point, Jen, I'm with you. I would advocate against codifying anything like that. I mean, to me, it seems like times change and situations change, and I worry a lot that if we were to create a codified hierarchy or anything like that, even directing the administration to follow it, it might be outdated 10 minutes later, or it might favor somebody over somebody else, or potentially even be viewed maybe as like discriminatory in some sense. So I think that's a very dangerous place to go. That's just my own personal opinion.
I have some notes on this policy. So under authority, I think that we should remove the verbiage that's currently there, and we should craft something to specify where the board gets the authority. That's what we're trying to do with our new format.
And to that point, when we were talking about the template, I was saying, there are some general things that say the board can establish policy. But this is one that might have a specific citation around the thing that says that the district can, there is something in school code that says the district can provide transportation, and if you do, you have to do these, a whole bunch of other things, and that would belong here.
Okay. And then, so we'd have the definition section, even if we don't have anything in it. Under the guidelines section, everything should start with the number 3. And then and then the AR. So the way it's set up now, like, we just discussed the AR, but ultimately the board, we don't write the ARs. So we kind of are just really discussing it. And I was just wondering if there was any additional information about what it says in there about students getting on. They can only get on and off at their assigned stop.
I mean, I think this is probably just, they are assigned to stop, and for liability reasons, that our policy has to say that that's where they are supposed to get on and off.
And then one last comment here. Let me see. Oh, okay. So there's a bullet point found under the heading Development of School Bus and Vehicle Routes, Stops, and Schedules. And it says the superintendent or designee may, based upon operational experience, assign students to vehicles at rates in excess of the above guidelines. So I think what this means is, like, if you have a bus and a whole bunch of kids are assigned to it, but they actually are in daycare, they never take the bus, you can put more kids, you can go above the guidelines. That's how I read it. But I just think we need a little phrase in there that says, something like, it will still remain within safety regulations or something. That's how I read that bullet.
Yeah, I read that the same way. That's the exact situation I was thinking of, is that half the bus hasn't ridden the bus all year, and because of the shortage, right, we're going to add some more students to that bus. But I totally agree. That doesn't mean we're okay having literally 4 kids sit to a seat. It's just,
We're just saying,
yeah, realistically, you're not going to have that. I don't know how to word that, but that is how I read it, is that it would only be used if you could still stay within those, 2 or 3 to a seat guidelines based on actual use of the bus. I don't know how you predict that, but.
I don't think you can, because this is the assignment to a bus, not the daily practice of, can we accommodate this many students on the bus? So the rule is, every student is assigned to a bus. They get a seat, there's a seat for them, whether they take it or not. And so I don't think this is about, half the high school students drive, and therefore there's realistically more space on buses. I'm not sure why it's here, but I don't think it's for that reason.
I was just going to say, I wonder if the bullet right after that actually covers what you're trying to say, that we have to maintain safety. Or maybe that language could be strengthened, but we cannot seat that we would encroach on the aisle clearance. And the PA school code is cited there as well. I don't know if that.
yeah, my notes are not at the actual.
I had another question in the meantime. For 2.5.1, transportation of students on field trips shall be provided in accordance with board policy and administrative regulations. I peeked at the AR, and I couldn't find anything about providing transportation, like accessible transportation for students with disabilities and making sure that they can access field trips or extracurricular activities. So I didn't know if that's somewhere else or if that's appropriate to include.
I think I don't remember what policy exactly that would be in, but if it's not in 121, it's in somewhere. And so maybe the problem here is that bullet 2.5.1 explicitly mentions 121, not 121 as an example. There's probably other citations that belong in there as well.
Back to the previous point, yeah, I guess that the following bullet is clear that the aisles have to be clear to keep it safe. So I guess that is, okay. Any other? Oh, yeah, go ahead.
Sorry, I had one I missed. So this is, sorry, I'm back in the policy now. This is in 3.5. Do we actually approve do we do this annually? Every year we do this? Am I just blanking?
We don't have any contractors.
Okay, So maybe that's why I don't
But
remember doing
yes-
it. Okay.
But yes, per auditor
You would have to.
requirements, we would have to if we did.
Okay, that explains why it did not ring any bells.
So my question was more around the video and audio recording. And it's not clear to me how the media created from that is kept secure. And so you're taking these audio and visual images on the bus, and then they get from the bus to somewhere else. And so it's not really clear to me, are these closed systems? Who's access to them? I see in the AR, it says the images and audio from the recording devices are for use by the district administration staff, but it doesn't say only by the district administrative staff. So just curious if there's more to be said about the security of the content that's created from the recordings on the buses.
There is other policy around recording devices that may, without looking at it, may be specific to in the building. I'm not sure if it would apply to buses, but we should probably check that. Because if it does apply to buses as written, then maybe that's covered already, we just need to cross-reference. But if not, then we may need more.
I was thinking the same thing. Usually we say district property, which we always define as buses included, but maybe cite that and ensure.
Is that okay, John? So we'll bring it back. This is first reading.
Yeah, that's helpful. It's just, the footage has to get physically somehow from the bus to wherever it's stored. So if it's on a server somewhere or there's a transfer of data. So the security, that's really important because they're kids. And so we want to make sure nobody else has access to that.
I mean, but there are, like, in there, it does say there are situations where they would show it to parents. So,
Yeah, that part I'm actually not concerned about.
Okay,
It's
okay.
more that somebody outside of that couldn't somehow hack into a system or, if it's transferred over Wi-Fi, somebody's sort of snooping on that and able to get that data.
okay.
Or what popped to my mind is, the camera's up at the front and there's just an SD card sitting there and it's telling a student can just pop it out and take it with them. I mean, I hope it's not the case, but you never know.
Put that in an email, don't say. Just kidding. Okay. Anything else? All right. We're down to first reading repeal.
And the only thing on our first reading repeal is 810.2. And this information is included in 810, so we're recommending a repeal.
We're okay with that? All right. Okay. So that brings us to public participation. Speakers are required to state their name and their city of residence or affirm they are a resident or a taxpayer in the district before addressing the board. Seeing no one approaching the mic, I'm going to close public participation. We have no written comments. The next policy meeting is Wednesday, June 5th, 7 p.m., or immediately following the Education Committee. And with that, we are adjourned.